Chair calls Andrew Homer, Texas CASA, testifying against.
My name is Andy Homer. I'm the Director of Public Affairs for Texas CASA. We are here respectfully in opposition to House Bill 1899. Haven't had a chance to see the substitute. We sent out language on this to our network. A lot of you know we have 72 local CASA programs around the state, and really our primary goal in all of that is to make sure that we represent the best interests of children in the legal system. So trying to change that standard is very contrary to our core principle. And as we read the bill, it applies broadly, I think, to all cases that apply under the family code is my reading of it. I'm not an attorney. And so we're particularly concerned about how this would apply in child protection cases. I think, you're talking about situations where parents have already shown they've demonstrated they're not able to be good protectors of their children. This would create a presumption that they are. It would create a high standard to overturn that. I'm not sure, and Representative Moody, maybe you could help with that, how we would determine whether they are unfit or not. Would there be a trial, an evidentiary hearing? This goes way beyond just codifying a ruling. So we are concerned about, situations where you have adults who've already demonstrated their inability to be protective of children, and then all of a sudden they're given the rights to make these determinations for a child when, they could, for instance, say we don't want a doctor to provide care under these circumstances. We don't think this is the best placement for a child, even though perhaps the Department of Family and Protective Services and everyone involved has concluded that a particular placement is in the best interest of the child, and the parent could override that, for instance. So really it just opens up a lot of things in this, and I don't think that this provision should apply to CPS cases. I mean, that's our bottom line on this. I think that you have substantially different legal circumstances there, and there's already grave doubt about the ability of parents or a parent in that situation, and they shouldn't be presumed that they're carrying out the best interests of the children. We should not presume that in these sorts of cases. So we feel very strongly about this. We let Representative Sanford's office know about our opposition, but we've just had this groundswell of concern from our network about this. And it's really trying to change the core principle of what the family protection, family practice is, and how we judge cases in our child protection system. So we think this has very grave concerns, and I'd be happy to answer any questions you may have.
Any questions of Mr. Homer, members? Mr. Homer, thank you.
I do.
Hold on. Representative Kane has a question.
Mr. Homer, you don't believe that there should always be a rebuttable presumption? That way, we kind of do that in all areas of our laws, even criminal, where we're innocent.
I think in this instance, if you've got a child who's already in the conservatorship of the state, there's already been a process that's determined that the parent didn't act in a protective fashion, and so I think they may have forfeited their right. That would be kind of my assumption as a non-attorney, and I know you're an attorney as well.
Yeah. Are you a father?
No.
Okay. All right. Thank you.
Any other questions, Mr. Homer, members? Thank you, Mr. Homer, for being here.